Okay, I think we have everybody here, so I'll go ahead and get started. Good evening, everyone. I'm Naomi Walker with the Office of Justice and Safety. For those that are new here, the O'Donnell Consent Decree was created following a class action lawsuit against Harris County from plaintiff Miranda O'Donnell, claiming that the bail system was unconstitutional. Specifically, O'Donnell reported that after being arrested for driving with an invalid license, she was detained in Harris County Jail because she could not afford to pay her $2,500 bail. The parties involved in this lawsuit reached a settlement agreement known as the O'Donnell Consent Decree. All parties recognize that the input and involvement of Harris County residents will be essential to meaningful and lasting reforms and effective for ongoing monitoring and evaluation of the system. As a result of the consent decree, public meetings occur every 6 months. Today, independent court monitor Professor Brandon Garrett, Deputy Monitor Professor Sandra Garrett-Thompson, and representatives of Harris County Attorney's Office, Sheriff's Office, and Presiding Judge of Criminal Courts at Law will discuss the fifth monitor's report, including consent decree implementation updates and completed milestones. After the presentations, we will allow public comments and questions by utilizing the Q&A chat box. Now I will turn the program over to the monitors, Professor Garrett and Professor Garrett-Thompson.
Thank you so much, Naomi, and thank you all of you who are here joining us. Sandy and I were really honored and enjoyed the opportunity to present to you all, many of you in person at our live public meeting, but it's also a treat to be able to present virtually to those of you who couldn't attend our last meeting in person. We're really grateful to all of the folks in Harris County who've been working really hard now for over 3 years to make these consent decree reforms possible. And now after 6 reports in 3 years into our work as independent monitors, reporting to the federal judge in this consent decree, we're in a position to say a lot more than before about how the progress has been going. And although our reports are lengthy and run over 100 pages, the kind of bottom line findings have remained pretty consistent, actually, surprisingly consistent since we first began this work. During, we were appointed as monitor, Cindy Garrett-Thompson and I, and Dottie Carmichael and colleagues at Texas A&M. We were appointed, within just days before the first COVID cases reached the Joint Processing Center and so many other detention facilities around the country. There have been enormous challenges due to those events and their impact on the jail and on courts. And there continue to be different challenges that everyone has struggled with. And yet, our updated findings, 3 years into this 7-year appointment, largely confirm what we've been reporting since the very beginning, which is that these misdemeanor bail reforms, the O'Donnell Consent Decree just governs misdemeanor cases, have saved Harris County and residents many millions of dollars, improved the lives of tens of thousands of persons who are arrested for misdemeanors in each year. And we found that these quite large-scale changes, and I'll say a little bit more about some of the really impressive implementation work that's ongoing and work that remains to be done. Despite these large changes in the system, we've seen no increase in new offenses by persons arrested for misdemeanors. And indeed, we've seen that in general, the number of people arrested for misdemeanors has declined by approximately 20% between 2015, which was well before this consent decree took effect, and 2022 last year. And so we've seen fewer people coming into the misdemeanor system. We've had fewer people in the misdemeanor system who've had new charges filed against them. So from a public safety perspective, that is a real win-win, and win-wins are few and far between in today's world. And in public policy, it's really exciting to see how when Harris County took on very ambitious reforms that really hadn't been attempted on this scale around the country, that 3 years in, we can see pretty remarkable positive effects. We've described in the past how there were marked racial disparities in who ended up in the jail and who didn't under the old cash bail system, where it was largely about whether you had money on hand, whether you ended up in the jail or not. Those racial disparities disappeared very early on when these reforms took effect. We've also done more sophisticated economic analysis, looking at the two time periods when these reforms were implemented, when a preliminary injunction was entered by the court, and then later when Rule 9 was adopted by the judges, which was then incorporated into this consent decree. The analysis is complicated, but what we found was that, just like we've described in our reports, kind of in terms of just simpler descriptive data, that we see really positive impacts in terms of arrest and rearrest rates, positive impacts on public safety. And that is counterintuitive to some people. The idea that you could be ensuring that so many more people have their liberty, so many more people are free, and for large categories of misdemeanor defendants, they're entitled to, presumptively, to a release bond at the point of arrest after they're booked. So the idea that you would have tens of thousands of people entitled to their liberty and yet public safety would benefit, that's a remarkable win-win. But we also want to highlight that there's a greater focus on public safety in the bail hearings that do happen for people who are not entitled to this presumptive release. That the bail hearings are much longer, much more substantive. You don't have 30-second, 1-minute bail hearings where there's very little discussion of anything having to do with, what are the real concerns here if this person is released, or is there a public safety risk? Is this person a flight risk? And so, we spend a lot of time watching videos of hearings and monitoring what happens in bail court. And the hearings are far more substantive. There are now public defenders at these hearings. There's much more information that's discussed in terms of what is the merits of this case. And, people are entitled to have that bail decision reviewed the next day. There can be a second hearing in front of a judge to revisit that decision. We've also seen decisions about appropriate conditions get revisited over time. And one thing that we report on here in this most recent monitor report is work by others by the Harvard Kennedy School. And they did a remarkable study of a program where, rather than just sort of set initial bail at a bail hearing and perhaps it gets reviewed the next business day if release is denied, but otherwise maybe only periodically, a number of the judges signed on to pilot a step-down program where there'd be automatic reviews every month. So more frequent reviews of the supervision conditions. And what they found with over 2,000 people, clients in this program, that when they stepped down conditions as they were succeeding, they found enormous cost savings because there was much less cost of over supervision of people. But they found that it was over supervision, that it would have been over supervision if they just stuck with the original conditions, like often happened traditionally. They found that both repeat arrests went down, that the court appearance was consistent. And so they found that it was in general very good for court outcomes and for public safety to have this more periodic review of supervision. And then supervision can be quite expensive. It's not always necessary to have every type of supervision. One of the really important things about this consent decree is that it calls for careful attention to what is the degree of supervision that's appropriate in a particular case. There's quite a bit of work being done to implement this consent decree. There are a new round of trainings that are about to be rolled out by SMU Dedman School of Law. SMU has been involved in designing a new program of training on this consent decree, which is an important work. I mean, it's an opportunity to, as a law professor, I care about education, and the idea that we should always be educating ourselves and improving ourselves as lawyers and participants in the legal system is that's Sandy and my life's work, and we think it's important. And we're excited about the hard work that SMU Decent is doing to develop a new set of trainings. We also reported in this latest monitor report that 3 years into this work, there is still substantial work that needs to be done to develop systems to detect consent decree violations or potential violations when they happen, so that there's learning from things that slip through the cracks, as will happen in any system, and to prevent costly and unnecessary errors when they occur. One common theme, as we noted in cases that we have seen recently where something wrong happened or improvements could be made, were cases which were really challenging ones involving people who are unhoused, who have behavioral health needs, or both. We describe in our report, in terms of our data analysis, that those are the people who often had quite low-level misdemeanor cases are more likely to return to the system, to have their cases disposed in a more prolonged way, to cycle. And those are also the cases that can pose challenges in terms of complying with the timing deadlines and the other procedural rules when you have people that have urgent needs in a jail setting. And there are certainly, policy questions facing agencies that arrest people who are homeless for trespass and theft. Trespassing and theft, for example, are a disproportionate share of the offenses charged against homeless arrestees. And there's a question about what the public safety benefit is in those cases. That's not, within the consent decree. What's within the consent decree, though, is the challenges that come up when you have people who aren't readily contacted by their lawyers, who may be in crisis when they arrive at the jail, and pose special challenges for the systems in place so far. And so we describe that there's a real need to have better systems in place to detect people who are languishing along the road to the bail hearing that they're entitled to, or the personal bond that they're entitled to, or the bail review that they're entitled to. So the kind of supports that need to be in place so that Sandy and I don't need to be monitors anymore. The system can self-monitor. On the theme of self-monitoring, we also describe in our report how the county has done remarkable work to design a really important plan around the topic of court appearance to provide better information to people navigating the court system. Even just basic things can be confusing to people. I myself sometimes log on to the wrong clerk's office website, which is a silly mistake, but there's more than one clerk, and you have to create an account. It's not easy for people to find out information about their court dates apart from their lawyers. And the plan that the county actors have cooperated on is really well designed, and awaiting some last input, I think, before moving forward. One more concerning topic, though, was that we learned, because the folks at Texas A&M on our team were trying to understand the data concerning people who are signing up for the electronic court notification program. And it just seemed like not very many people had been enrolled in the system, and the data just looked funny. And so those are the kind of questions that can provide really useful information when data looks off. And in the process of doing some detective work to try to understand these low enrollment levels, it was uncovered that there were a whole series of failures that led people who thought that they were signing up for a court appearance notification to not get actually enrolled, and therefore not get the notifications. So a number of things were going wrong, and the county has been responding and trying to fix these issues. But there are people who are signing up in person, and their information was not getting entered in the system. There's also people whose information was getting entered electronically, and that wasn't getting entered into the system. And that's obviously concerning, because these people may have been expecting to get reminders about court, and they weren't getting it for almost a year. And so these issues really highlight the need for simpler ways for people to be able to check on their court appearances and be notified of them. We're glad to have realized that this was happening, and really appreciative of the hard work of county officials who have jumped to try to fix these issues. There's going to be a lot more important work to come. This consent decree also called for a series of recommendations coming out of studies regarding the quality of indigent defense in misdemeanor cases, and the county's working on a plan regarding those recommendations, and that will be really important work as well. On our own end, we're also doing further analysis regarding, and I mentioned homeless people with behavioral health needs, who we see cycling in the system. We're trying to understand where that cycling is happening and understand that phenomena better. You think about public safety and recidivism a little differently if it's the same homeless person being arrested over and over again for theft. And that's not necessarily a problem that the bail system can solve, but the county has done important work to try to address some of these problems, far outside this consent decree. And to the extent that we can dig into the data better to understand what might better prevent that kind of cycling, which is burdensome for courts and and doesn't necessarily solve the underlying problem. And we want to do the best we can to inform other county actors that care about these problems from their own perspectives. So I'll stop there. We regularly engage with a group of community stakeholders. We met with them just after our last in-person public meeting. And I'll turn things over to Professor Sandra Guerra-Thompson to talk a little bit more about that work and some of the other engagement that we've done as part of this project that we are now over 3 years into.
Oh, thank you so much, Brendan. So yeah, again, I'm Sandra Guerra-Thompson. I'm a professor at the University of Houston Law Center. Professor Garrett is at Duke University School of Law. And so we really have a lot of university faculty coming together on our team. You know, it's been really rewarding and exciting work. I'm kind of the Houston contact for our team. You know, just to step back again, like Professor Garrett was explaining, the changes brought about by O'Donnell were pretty dramatic. So before O'Donnell, tens of thousands of people spent about a week in jail on misdemeanor charges. And we now know that jail time was unnecessary because O'Donnell changed things, and now most people are much more promptly released without having to pay money. And as he said, the rule carves out offenses that have public safety concerns. And those are the only cases now that go to these better hearings where they have representation. The other people are much more promptly released without having to pay money. And what we're finding is that this change, this paradigm shift is working, right? That it's saving taxpayers enormous sums and saving Harris County residents money in the sense that they would otherwise have had to pay for their release when they got arrested, and now they're not unnecessarily having to pay that money. So they can hold on to their money and pay bills, pay for attorneys, and the like. So this is a huge shift, and it's only been made possible through a lot of community efforts at the county level. You know, we've been working closely with the district attorney's office and talking most recently with their mental health diversion group and hearing about the good work that they're doing to try to get cases out of the system, get people into mental health treatment so that they never go into the jail, and instead they can get the help that they need and prevent them from returning to the criminal justice system in the future. We've also spent a lot of time talking with other agencies like the Public Defender's Office that represents everyone who goes to those bail hearings, the new Office of Managed Assigned Counsel that's doing a much better job of overseeing private attorneys who are representing people in the criminal justice system. Pretrial services, Brandon talked already about the kind of step down program that they've been implementing with the cooperation of the judges and the county criminal county courts at law, and trying to reduce the amount of supervision that is done to the level that is appropriate and not excessive. We've talked with the Harris Center and the kind of diversion programs that they have implemented, as well as Harris Health, which provides medical services in the jail. And again, all of these agencies now are working together with law enforcement, with the Harris County Sheriff's Office, HPD and other agencies to try to divert people as much as possible and get them out of the jail whenever possible. And, you know, really maximizing liberty interests while at the same time balancing that against concerns about public safety. So for example, cases of domestic violence, multiple DWI cases, people who are already out on bond, those kinds of cases get carved out and handled separately because they do raise public safety concerns. But if they don't have those public safety concerns, then what we're finding is that we're much better off as a society really respecting people's liberty interests. Because again, these folks are not automatically guilty just because they're arrested. They're presumed innocent. And so we're finding that this has been a very, very effective change in Harris County. A lot of people have raised concerns. They read in the papers about backlogs in the criminal justice system, too many cases piling up. And that really was a problem after Hurricane Harvey, which created a lot of problems in the courts. And following on the heels of that, we had COVID. So there were enormous backlogs in the court dockets that had built up. But we, on our recent trip in Harris County, we were told that these backlogs are now reduced to pre-COVID levels. So that's really exciting. The monitor team also has worked very closely with a lot of other community partners in the provision of services to the homeless. We've worked with Beacon, with Search, with the Coalition for the Homeless, with healthcare providers such as Healthcare for the Homeless. We've talked to agencies that represent survivors of domestic violence, like Tahira, that works with immigrant groups. We have close relations with our law enforcement partners at Harris County Sheriff, of course, as well as at HPD, who've been really terrific in sharing data with us and in their willingness to talk to us about a lot of the kind of policies that they implement and what we're seeing in our data. We've worked with advocates for women who go through the system, who are involved, for example, in sex trafficking, and groups like Angela's House have been enormously helpful to us, as well as advocates for civil rights, groups like the Greater Houston Coalition for Justice, the Texas Coalition, Texas Criminal Justice Coalition, the Texas Organizing Project, and the NAACP. And those are just some of the groups that we have been working with, and we're really grateful for that. And I would just end by saying that I think one of the things we're seeing the fruits of is something that I think that Harris County, the people of Harris County and the city of Houston should be really proud of the work that's being done to try to address the issue of homelessness in our county. We're seeing the progress that has been made in the last couple of years that has gotten national attention. And we're seeing the benefits of that in the criminal justice system as well. So the criminal justice system really often is the end point when other social problems get out of hand, and nothing else is being done to address those issues. Then they call the police, and these things end up affecting the jails. So we're really seeing a lot of progress that has been made in the community on that issue, and that has a great effect, especially in the misdemeanor area. As Professor Garrett said, we're still seeing too many people being arrested for trespass who are homeless or who have behavioral health needs, so there's still a lot of work to be done, but it's getting better. So with that, I'll turn it over to some of our Harris County participants to speak as well.
Thank you, professors. Next, we have Rachel Frazier, Senior Assistant County Attorney.
All right, give me a second. There we go. So I'm having some technical difficulties, but I am Rachel Frazier from the Harris County Attorney's Office. At the County Attorney's Office, we continue working with stakeholders to ensure that a constitutional and transparent criminal justice system is in place while working to also ensure public safety. Our office provides legal advice, representation, and also contract management to help county departments and officials comply with the consent decree. One of our current projects is to help our stakeholders comply with Section 7 of the decree, and that's we're advising them on incorporating recommendations from the NAPD, National Association for Public Defense, into the county's indigent defense plan. We're also working right now to help our stakeholders comply with Section 55 of the consent decree by working together to develop a plan and improve misdemeanor defendant appearance rate in court, as Brandon talked about. And at the County Attorney's Office, we look forward to continuing our work with the monitor and the stakeholder to continue improving the criminal justice system in Harris County so that it can be the best that it possibly can be. Thank you.
Thank you, Attorney Frazier. Next, we have Major Patrick Doherty.
Good evening. My name is Major Patrick Doherty. I'm representing Sheriff Ed Gonzalez in the Harris County Sheriff's Office. We play an integral role that everyone who is arrested in Harris County and charged with a misdemeanor or felony crime are brought to the Harris County Sheriff's Office jail, the Joint Processing Center, which I am in charge of. At the Joint Processing Center, they are processed into the jail. They are charged to the District Attorney's Office, and they are brought to the pretrial services. And if they're a misdemeanor and under the consent decree, there are numerous misdemeanors, what we call low-level type misdemeanors, nonviolent misdemeanors, that they will be processed out through a pretrial type bond and released to the street. It's our responsibility to ensure the process is done in a timely fashion. And if there are some hangups in the time fashion, then we enter into a procedure that allows us to release the individual. Of course, the more serious type crimes will go before a magistrate and will be handled through that process. If you have any questions regarding the process of processing in new arrestees, I'll be happy to entertain those questions. Thank you.
Thank you, Major. Next up is Judge Alex Salgado.
Good evening, everyone. I'm Judge Alex Salgado, Judge of Harris County Criminal Court at Law Number 1. I am the co-presiding judge of the 16 courts of the misdemeanor courts here in Harris County. Probably we're very responsible for making sure that the consent decree Rule 9 is followed on a daily basis, and that we continue to do the good work that the reports have shown that this consent decree is working. I can't thank the monitors and their team enough, the entire judicial system here in Harris County. It's a lot of work to make sure that this works, and it's been working so far. I think the facts show that. So we will continue to do the hard work, and we look forward to our continued efforts in making sure that the consent decree Rule 9 continues to apply to every misdemeanor arrestee that comes before us here in Harris County.
Thank you, Judge. If you have any additional questions, you can put them in the Q&A box. I don't see any in there yet, Brandon, so.
Certainly grateful for questions. We had a few really good questions when we had our live meeting.
I don't know if we're going to get any questions tonight. It's a short night, so I guess if we're not going to get any questions, then oh, here we go. Christine Baldwin asked, what if anything will change since there has been a recent ruling?
County attorneys may be the best to answer it. There's another case out of Dallas, so it's not in the O'Donnell case, and our job is to follow up with implementation and work under the O'Donnell consent decree. So we haven't been paying too close attention to what's happening in other litigation, the O'Donnell case is a consent decree, and when cases come to a judgment like that, it's pretty unusual for them to not, when a case is final, it's final. So I'm not sure other litigation really has particular relevance in this case. But one knows to never be certain about anything in litigation, and I'm not the one to really ask. I haven't been following these other lawsuits.
And I think that's very well said, Brandon. At this time, right now, it does not have any effect. We're going forward with the consent decree and Rule 9, as this is about misdemeanor bail reform. And if something changes from here, that remains to be seen. But I'd agree with Brandon for right now.
Okay. If we have no further questions, then conclude our meeting for tonight. Thank you all for joining us. Good night.
Thank you.
Thank you all.
You.